Court coordinators European law from 9 member states met in The Hague. Could interconnection of their networks contribute to the improvement of application of European law? And what is the role and function of modern technology? These questions were discussed during the conference Europe Interconnected.
Ladies and gentlemen, in these days in which there are so many forces that seem to split the European Union, it is for me, as chairman of the Netherlands Council for Judiciary, a privilege and an honor to a very inspiring man and a very inspiring moment to welcome you all to this conference here in The Hague, titled Europe Interconnected. Eurinfro, that started as a project coordinated and fully financed by the Council for the Judiciary, now has a permanent status and has the following objectives: to improve the accessibility of European law information resources using web technology, improving the knowledge of European law amongst the Dutch judiciary, setting up and maintaining a network of court coordinators European law, the CCEs. Knowledge is constantly changing, so the management of knowledge has to change as well in order to remain effective. I am convinced that improvement of knowledge management can be realized more easy and more effective by working together. That is why the Council for Judiciary in the Netherlands embraces the initiative of the Dutch network.
My idea is that we have to promote in the community of judges and legal operators a possible connection, permanent connection, because this is the time more than of globalization, the time of relationship. A very great opportunity to have many relations.
And that means that you have to exchange experiences, but
Yes.
also go on a visit in Italy and
Yes.
work there for 2 weeks or 2 months,
Yes.
that you can see how they work, or they go to
But
Greece.
this can be done, but not so often because it costs. You don't have time to go there, and so it could reach only few members. You have to do that, but add all opportunity through the web. In this case, you can multiply it, but this must be organized. What is the merits of Eurinfra or things like that that are now being coordinators and
Must
so
it be
forth?
organized bottom up?
They organize. When Winter speaks, I hear the jurist speaking, but also a managing engineer.
Yes.
He has both sides,
Yes.
and he's organizing an engine that works. And we have to do that.
I do wholeheartedly agree with this view of the European Parliament. Judges and their staff should have all the relevant information at their disposal in a state-of-the-art manner. By apps, by mobile websites, the general part of the Union law could be a start. In that respect, we should avoid the situation that every member state now starts to develop their own technology and their own digital structure to supply their judges with such kind of practical tools to gather basic information in a user-friendly way. That would be a waste of energy and financial resources. In my opinion, this, all taken together, complies with the vision of the European Commission as well. The Commission underlined in its communication from September 13 of 2011 that duplication of efforts can be avoided and that the reuse of quality training products can be promoted. Good practices should be exchanged.
So we need to think about Europe. So we need to know, we need to see how we can read and implement EU law, how we can be efficient. This is both for the national systems, of course, and in particular in these critical financial times that we face, we need to take all challenges up and make work better together.
In fact, that means more interconnection between the member states in EU knowledge management as well. Every time member states are planning to supply their judges and legal staff with digital tools, They could consider, would this be profitable for the judiciaries in other member states? That counts in particular when a member state considers to introduce tools that are merely designed to improve searching plain information, like judgments, conclusions, and EU law. The best approach would be when this kind of elementary up-to-date searching tools would be designed as a result of coordination between the member states or directly on the union level.
With the disappearance of borders within the European Union, it is very important that we judges cooperate and collaborate and work together to overcome all the problems that can result from the disappearance of controls and borders. And in this sense, this initiative is extremely positive because it is very important to know what colleagues are doing in other countries, because after all we are all trying to interpret and to enforce the same legal provisions.
Every time before a seminar will be given, the question should arise: could this lecture be profitable for other judges and judges in other member states? These kind of lectures could be saved on video and made usable by voiceovers or subtitles for judiciaries in other member states.
First of all, the setup is great to start with.
Thank you.
It's a very nice hotel and I think it's very suitable for the purpose. Everybody is very close, so it's easy to get interconnected.
When we would succeed in realizing an interconnection between these networks of coordinators, we would create an EU law rapid deployment force. What seems to be a weak point on the European level and what has been crucial for the success of Eurinfra at the national level is a pivoting point that coordinates the different activities of the stakeholders within these three pillars and between these three pillars of knowledge management. Such a pivoting point may be temporary and may be operating as a small network, could meanwhile contribute to the coordination of activities in different existing networks. What in my opinion is missing is an outline for an operational master plan concerning European law knowledge management. This coordinative pivoting point could contribute to the making of such a plan, in which should be made a clear distinction between information, knowledge and skills, and networks, and what the role and function of technology could be in these respects.
Well, I was much impressed by all the presentations of the 8 delegations of this conference. I think their presentations make very clear to me that we are at the beginning of a process of international cooperation, the interconnection as it is called, and that we need also some person, like we have it now, the national coordinating for the European Union law. We also need, on the level of the European itself, a coordinator to coordinate.
Ladies and gentlemen, we are reaching now the end of this conference. After 1.5 days of presentations, discussions and lectures, after hard working, inspired listening and enjoying each other's company, it is time to draw some conclusions. Judges throughout the Union are entitled to have easy access to judicial information in a state-of-the-art manner. The development of technological searching tools like apps, mobile website, should be done as much as possible in cooperation to avoid waste of financial resources. Support from the European level, as well as coordination between the member states, is needed to avoid such a waste. Contacts between national CCE networks on a more structural basis, the so-called interconnection or enlargement, must aim at the uniformity of the application of European law. Participants in an interconnected or enlarged network must be able to exchange views, opinions and best practices in an environment in which they feel safe and secure. I thank you once more for all the contributions that you made.